introduce our esteemed speaker, O'Neill Dewey. He is the Strategic Partnership Manager at Trust and Will, and they are the largest digital estate planning platform in the United States. O'Neill focuses specifically in the credit union space, supporting partnerships with 80 plus credit unions across the country and providing estate planning tools and education to their 25 million plus members. O'Neill lives in New York City, where in his free time he enjoys exploring new restaurants and playing tennis in the Hudson River Park. Well, O'Neill, welcome, and I will give you the floor. Thank you so much.
Thanks, Christine, and thank you everyone joining us today for our Estate Planning 101 webinar hosted by CalCoast. Appreciate you welcoming us into your homes, your workplaces, wherever you're joining us today. And I'll be your host today. My name is O'Neill, as Christine mentioned earlier. Yes, believe it or not, that is my first name. I manage all of our credit union partnerships here at Trust and Will. We're working with over 80 credit unions, but CalCoast was our first partner, so we're especially appreciative of all the work behind the scenes they do to help members with financial wellness. I'm joined today by my colleague Jason Young from our member support team, who is manning the chat box below. So if you look to the bottom of your screen here, you should see a Q&A box. And please feel free to jump in and ask your questions as we go throughout this presentation. I'm sure you'll have questions as we move throughout, and it's best if you ask them right away so that you don't forget them. And Jason will be in there. He'll answer them as they come through. So as we're moving through the presentation itself, please utilize that chat feature. But back to the topic at hand. Today, we'll be discussing the basics of estate planning. We'll start by defining why an estate plan matters and what an estate plan is and does. Then we'll cover some of the key documents in an estate plan and how to decide which documents are best for you. And then finally, we'll conclude with who needs an estate plan, some of the most common reasons it might be time to create or update your plan, and how you might get started doing so. Once again, as you have questions, please pop them into the Q&A below. To set the stage for the gravity of this topic today, it's important to remember that estate planning is the largest personal transaction of your life. That said, it's typically also the piece of financial well-being that is least prepared for by families. And without a plan, most people end up leaving their assets and legacies subject to probate, which means the government makes all decisions on your behalf. And unfortunately, nearly 2/3 of American adults procrastinate on their estate plan until it's too late. And the three primary factors we continue to hear for this are, one, a lack of education around the risks of not having a plan in place, something we're hoping to tackle with this presentation today. Secondly, the cost. You can typically expect to pay thousands of dollars to draft estate plan documents with a traditional attorney, which is a price tag that is easy to procrastinate on. And then third, inaccessibility that comes when you are not quite sure who to turn to do things properly the first time. And so that's why California Coast Credit Union has partnered with Trust and Will to help you through these hurdles with modern, affordable estate planning solution. But first, we're going to talk about what estate planning is. And again, remember, this is all educational material. It's not supposed to be reflective of any legal advice for you specifically. So what is estate planning? Estate planning is planning today for what happens tomorrow. At its most basic level, an estate plan lets you make decisions today about what should happen if you are unable to make decisions in the future. This set of instructions specifies what you want to happen to your assets, your belongings, and your physical body. So why should someone care about estate planning? What should motivate you to actually getting this done? There are tons of reasons to care, but first and foremost, it's peace of mind. You will feel confident knowing that you've taken the necessary steps to protect yourself and your loved ones in the future. You'll also be able to name legal guardians to care for your minor children and pets. Another reason estate planning is important is that it can help you prepare for potential incapacity during your lifetime. So studies have shown that the majority of Americans will be impacted by incapacity, whether it's their own or a loved one during their lifetime. And because this happens during your life, it sometimes matters most to people. And these are all inherently personal decisions. So there's really no default, easy way to make these decisions, and for those decisions to match what your desires are. And so when it comes to estate planning, really there are a number of primary motivations, and those can be asset distribution. And so asset distribution is the ability to control where your assets will go after your death. You can choose to have the assets benefit your family and your loved ones, to support charities or organizations and causes that are important to you. And you can also plan to minimize taxes or maximize the benefit to your end beneficiaries. And most people equate estate planning with asset distribution, but it's certainly not the only part. There are also succession planning, end of life planning, and incapacity planning, which relates to your healthcare documents, all of which we're going to cover in this webinar. So we've gotten the why estate planning down, but what is an estate plan? An estate plan is a set of documents containing instructions for what should happen if you cannot speak for yourself, whether you're incapacitated or have died. An estate plan typically is multiple documents, not just one. And these documents are in each plan will vary person to person, but should be tailored to meet your needs. Each type of document is designed to do one thing. So your plan might focus on a number of things, in which case you'd have a number of documents, or it can be a full suite of those documents, which most commonly are wills, trusts, and healthcare documents, which we're going to dive into each specifically. So your last will and testament is a legal document that controls most assets when you die. It goes into effect after your death. So what is its purpose? A will handles fundamental needs for everyone. Therefore, if you are at least 18 years old, a will can benefit you. There are three primary functions of a will: to determine who will receive your assets after you die, to nominate guardians for your children and pets, and to specify your final arrangements. For example, do you want a traditional funeral or a memorial? Do you want to be buried or cremated? Those kinds of decisions. So logically, the next question most people have is, what happens if you die without a will? The thing is, the functions of a will are essential. So these decisions, who will get your things and distribute your assets, have to be addressed one way or another, even if you don't have a will. So what will happen is state laws will fill in gaps to make decisions on your behalf. And this is one of the most common misunderstandings of estate planning. Many people assume that these default state laws will give the same results as you would want for yourself, but that really is not always the case. And I want to give you an example today to explain that further. So let's say you're married with 2 children. State laws may provide that your assets are divided 1/3 to each family member. And you may not want your kids to get 1/3 of all of your assets right when you die. Your spouse might not be able to maintain the house or standard of living with only 1/3 of those assets. And depending on your state laws, this is what can happen if you die intestate. However, with a legally binding will in place, the court will likely honor your wishes as stated. So let's focus a bit more on how a will works after death. Wills go through probate, which is a judicial process to determine the validity of a will and to appoint an executor. If you don't have a will, the court will appoint an administrator to perform the same functions as an executor, usually a relative, but if you have no will, it may not be the person of your choice. The executor, once appointed, is the manager of the probate process. So their job is to collect assets, to pay debts, expenses, and taxes associated with the estate, and then to distribute assets to beneficiaries. But probate is often undesirable because, first off, it's slow. Before COVID, it could take 12 to 18 months in California, but in some state courts, you can expect over 2 years, 24 months plus, to move through probate, which is painfully slow. 2, it's difficult and stressful. The process begins immediately after death during a period of grieving for loss. And because of this, it often brings out resentment and can lead to interfamily or friend disputes. And third, it's expensive. In some states, a $1 million estate can cost $50,000 in statutory fees for probate. So probate avoidance is a huge motivator for some, and it's one of the primary reasons that many will look to set up a trust. A trust is a legal agreement between three parties. There's the settlor, trustor, grantor, who creates trust and puts the property into it. There is the trustee, who holds and manages the assets in the trust. And then there's the beneficiary, who the trust is in favor of. So basically, the settlor creates a trust and gives assets to the trustee to hold for the beneficiary. There are 5 primary purposes of a trust. First off, to avoid probate. So this is key for many people. A trust is an easy way to avoid all those negative consequences of probate we discussed earlier, but it's not all about probate avoidance. A second reason would be to manage and distribute assets. A trust will give you more control over when and how assets are distributed, with contingencies you can add to a trust. Third, a trust applies both during your lifetime as well as after death. So this means a trust can be useful for planning for incapacity and to ensure there is seamless transition of control. Fourth, to provide for your family. This is a big motivator for many with younger children and blended families specifically. Trusts give you more control over assets that will eventually benefit your younger children. Trusts can also give more control over providing for your spouse for his or her lifetime, but then ensuring those assets pass to your children after your spouse's death. And fifth would be to minimize taxes. I also want to touch on the role of a trustee. A trustee is similar to the CEO of a trust. You're bound by law in terms of the trust, but it's still a critical role in executing all of those duties. A trustee can work with other professionals and advisors as well. So when choosing your trustee, you'll want to select someone who has the ability to carry out a lot of those duties. So popular choices are your spouse, a child or children, relatives, close friends. And there are 4 buckets when considering types of trusts in general. You've got revocable living trusts, which are the most commonly used type of trust. When people think about trusts, they're typically thinking about revocable living trusts, and these are created while living. They can be changed or revoked during your life, and the assets within will avoid probate. A second category would be testamentary trusts, which are a little bit less commonly used, but they're created under a will. And a testamentary trust is only effective at death. These can be easier to create, but typically do not require, or they typically do require probate. Depending on the complexity of your state, there are also other categories and types of trusts, including trusts used for tax planning purposes. Examples of those might be credit shelter trusts, Q-tip marital trusts, irrevocable life insurance trusts. And there are also trusts used for other purposes, such as special needs trusts, asset protection trusts, Medicaid planning trusts. So as you can see, there are a number of different options out there. But trusts and wills have similarities and differences. Each do things that the other does not. The similarity lies in that both documents dispose of assets. Some differences are that trusts avoid probate, whereas wills go through probate. Trusts give greater control over when and how assets are distributed. Wills can be easier to set up. Trusts can sometimes take a little bit more work. Trusts apply during your lifetime, and wills nominate guardians and specify final arrangements. Typically, trusts are paired with a will as a set. So when should you, joining us today, consider setting up a trust? One reason might be if you have younger children. Rather than having all assets go to your kids immediately or when they turn 18, a trust lets you set triggers for asset distribution. Some trigger examples could include a child turning a certain age or hitting some sort of life event. You could wait till they graduate from school or get married, and these can help stretch out distributions. Another reason to consider a trust is if you have complex family dynamics, blended families, second or third marriages. Trust can let you benefit your spouse for their lifetime, but then ensure your assets go to your kids. not to a second marriage or to a stepkid. Another reason is privacy. Wills become public through probate, but trusts actually will stay private. And a final reason is if you have a higher asset level. Trusts avoid probate, which in California, I believe, kicks in for estates with about $160,000 in assets. For trusts, you can minimize estate and income taxes. So federal estate tax kicks in, I believe, around $13 million today, but this could be lowered based on the administration in office at any point in time. And trusts provide the opportunity for more advanced planning. They can help you stretch out retirement distributions. For example, if you have retirement savings that you plan to leave to your beneficiaries, a trust may provide a tax advantage way to distribute those retirement savings over time. So we've covered wills and trusts. Let's talk about the third of the common estate plan documents, which are your healthcare documents. And those typically are categorized in three types. You've got your power of attorney documents, healthcare directives, and HIPAA authorization. These three documents cover what happens when you are incapacitated. So while a will or a trust covers what happens to your property when you die, this part of your plan covers your wishes for your finances and care while you are still alive. Your power of attorney designates someone to make non-medical decisions for you. So those could be financial decisions, business decisions, any handling of day-to-day transactions, bills, things like that. Your healthcare directive, or also it's known as a living will, specifies your medical preferences in advance and designates someone to make other medical decisions for you when you're not able to voice them for yourself. And your HIPAA authorization ensures your designated agents and representatives can speak with your medical providers. So they can make decisions on your behalf, consider costs of treatments and things like that. And it also ensures that stakeholders in your care have access to your private health info and can communicate with care providers about your medical history and decisions. So one more piece that's often overlooked. So who needs an estate plan? All adults need an estate plan. Common reasons you might create one are marriage or divorce, if you have children, grandchildren, or adopt any pets, accumulating assets, bumping into potential medical concerns, or dealing with the loss of a loved one in your broader friend group or family, and then approaching retirement as well. And your plan should evolve as your life does. So this is one piece that's especially important. A lot of people on this call today may have created a will in the past, but your life has likely changed a lot since then. And so you'll want to consider updating your estate plan when or some changes you might want to make to your estate plan as your life evolves, or updating beneficiaries, changing guardians as your kids get older. They may need a different guardian. And generally speaking, you're just going to have different preferences for your life as you age. Common triggering events that may want you to really get this done, these updates done today, are births, deaths, changes in marital status, retirement, and just the general passage of time. We like to say every 3 to 5 years, it's worth revisiting. And as children become adults, they'll need their own plans. So while your child is under 18, you have parental rights. However, once your child turns 18, they'll need to have legal documents in order for you to allow you to act on their behalf. Once you've chosen your plan, you'll only need a few things to get started. I promise it's not as intimidating as you might think. You'll need some basic information like you and your spouse and kids' full legal names and birthdays. You'll need an idea of who you want to act as guardian for your children or pets, and who you want to appoint as your executor or trustee. You'll want to know how you might want your assets distributed, what percentages go to who, and you'll want to include you can include specific assets like jewelry, your car, if you have cryptocurrencies or anything like that. Or you can simply state, I'd like a portion of everything I own to be divided amongst specific individuals. And lastly, you'll need the names of financial institutions where you hold accounts, as well as the addresses to any real estate and or applicable names of businesses that you may own. But that's it. What you will not need are social security numbers. You will not need bank account numbers or online passwords. You will not need real estate titles or any other relevant business ownership paperwork. So like I said, it's not quite as complicated and scary as many people assume. But if you're still a little confused or not sure where to get started or want to do more learning, we've got hundreds of articles, Trust and Will, on our website, simply for the purpose of educating and informing people about all of the different intricacies of estate planning. And on our website, you'll also have access to our member support team that can help answer questions. I see some Q&A coming through already, so remember to keep throwing your Q&A in the bubble below. But on that note, I do want to share a little bit more about Trust and Will and how our services operate today. We are the leading digital estate planning provider in the United States and have helped over 750,000 families across the country today in all 50 states to create their estate plan documents on average, saving over 70% versus what you might spend with a local attorney to draft probably comparable documents. We are SOC 2 compliant. We've got our bank level security and encryption, so you can know that your information is safe with us. Again, you're not storing social security or account informations in general, but you think of us like the TurboTax of estate planning. You can go through each step of the process, one step at a time, save your progress, come back to it later, and you can see here very affordable packages and pricing for families. So our will package, we only have two offerings today to really simplify it for families. A will-based plan is going to include your last will and testament, living will, HIPAA authorization, power of attorney documents, all state-specific, designed by our team of attorneys, but really customized by you to fit your needs. You can see there's a special 25% discount that you'll get through your membership with CalCoast. And so that brings down the price to $150. Hopefully it's as more digestible than the big $1,000 price tag you would get with shopping this around to local attorneys. Our trust-based package starts at $499, but with the 25% discount, it comes down to $375, and that's going to include everything in your will package, as well as a revocable living trust, so something that can be changed and altered in the future. Hopefully, these offerings can help support you. But if you're not quite sure where to start yourself, we also have a quiz on our site that can help guide you to a will or a trust that could be a better fit for you based on some answers to a couple quick questions. And from there, it's a very intuitive and quick process. You answer one question at a time. On every page, you'll have some additional context related to the question being asked in a chat, as well as a chat bubble, as you'll see in the bottom corner here, which you'll be able to pull up a live chat with our member support team, like Jason's colleagues, as you see below. And what's unique about this is that these are real people available to help support you through this process. A lot of our members go through without needing, to answer any questions themselves. But if you do have questions, we'll hop in and help support you, helping provide you with education and resources. Our member support team will not, offer you legal advice themselves, but they can answer the majority of questions and provide you with continued education related to the question you're asking. That said, we also have a attorney support tier. So for an additional $300 flat fee, you can actually purchase our attorney support, which allows you to have multiple consultations with a local estate planning attorney that can offer you legal advice based on your circumstance and help you sleep better at night, knowing that your final documents have been reviewed and approved by an attorney. But to get started, all you really have to do is go to the CalCoast website and search for estate planning. You'll see a page with more information about Trust and Will there, and a link which you'll use to get that 25% discount. This is available through April only, this increased discount of 25%. So get started today. Finally check this off your list. It's on everyone's list who's on this webinar today. And so hopefully we can help you sleep better tonight, knowing that you were able to check this off. It takes about 30 minutes to an hour on our website, and you'll get a physical copy printed and shipped to you of your documents in the mail once you complete it. So that's it from me today. I hope this was helpful and educational for everyone on the call. We're going to open it up to any additional questions that might be coming through at the end, and then we're going to pass it off to the CalCOAST team to help close us out. But yeah, let us know if there are any more questions. We have a few more minutes here for you all.
Great. Thank you so much, O'Neill, for such valuable information on this topic and for telling us all about trust and will. Great presentation. So we will allow a few more minutes for Q&A, but while that's happening, also wanted to give a big thank you to Jason for handling all the questions that did come through and are still coming through. What I want to do now is pass it off to my colleague, Andres de la Mora, so that he can share a bit about business development in CalCOAST products.
Hi, everybody. Thanks for joining the webinar again. I'm happy to see you guys here. I was managing the chat a little bit, and I had put some information in there regarding Trust and Will and that special link for you to get the $25 discount. I'm also going to insert my contact information if you have any questions regarding any other CalCOAST products or services like loans, credit cards, mortgages, savings accounts, certificate products. We have some really nice promotions right now, so please don't hesitate to contact me at any time. You could call me, text me, or email me. I'm happy to help. I'm just going to hand it over back to Christine to close up the webinar. Thank you so much.
Great, thank you. And before we conclude, I would like to remind you that as an attendee, you'll be receiving a feedback form, a survey at the end of this presentation. We'd love to hear your comments. And if you fill that form out, you will be entered into a drawing for a $25 gift card. Please know that the feedback forms are anonymous. But if you would like to be considered for the gift card, you'll need to enter your name and contact information so we know how to reach you. And for future webinars, for our webinar in May, we ask that you please log into calcoastcu.org to learn about the upcoming webinars that we will have scheduled. So until then, we encourage you to visit our website, Enrich, which is a free financial wellness resource. There you can take a money personality assessment, and there are lots of articles and videos that may be helpful for you. Also follow us on social media. We're on Facebook, Instagram, and YouTube. And it looks like now we're getting quite a few questions. We've got about 5 questions here pending. So I think Jason probably needs a minute or two to wrap those up. But O'Neill, is there any last parting words before we log off so we can give Jason the opportunity to hopefully answer the rest of these questions?
I would just say that, regardless of whether, you have a connection or a family friend or someone who can help you with estate planning, we're a good resource for education. So, even if you don't, decide to set up your estate plan through us, please feel free to connect with us over chat on our website. We're here to help you. Our goal and mission is really to just make estate planning more affordable and accessible for families, because everyone should have a will. It helps support your family at the end of the day and your loved ones, and it really can help you plan ahead for what is the largest financial transaction of your life. And so something to take seriously and to prioritize. So we're here to help with very simply just providing education, if nothing else. So thanks for your time today. And we're looking forward to hopefully hearing from you over on our website. And big thanks to CalCOAST for having us.
Thank you, O'Neill and Jason. I think what we'll do is, since the webinar did end a little early, if you're okay with it, we can stay on for a few minutes to address the rest of these questions. Does that work for you, O'Neill and Jason?
Yeah, we can hang in for another few minutes here.
Okay, so we'll stay on for just a couple more minutes, and then hopefully if your question is not answered, you can look on the chat. We've got all of the contact information for Trustin, Will, and Andres there so that you can reach out after we disconnect the call in case your question wasn't answered. But we just thank you so much for joining us, everyone, and enjoy the rest of your day. Remember that this will be on the CalCoast YouTube channel in case you need to revisit some of the information. We'll see you next month in May. I see I see there's 14 outstanding questions, O'Neill. So your team might be busy after the fact. I'm sure people will reach out.
Yeah, and if you don't get your question answered today, as Jason is moving through these, please feel free to simply repost it on our chat on our website. So click through from the CalCoast website. Again, you're searching for estate planning, and if you click the Get Started button, you'll see a small disclaimer that you're leaving the CalCoast website, coming over to the Trustin Will website. You'll see that special discount that gets auto applied at checkout. So no need to remember any special codes or anything, but this is available through April. And if you have questions, you can simply pop open the chat bubble. You're going to see, our AI tool help answer any really quick common questions that we get. But after that, it will be prioritized amongst our member support team. So if there are questions that the AI bot can't answer right away for you, it will be quickly up. It will be pushed up to our member support team to help jump in and answer those questions for you.